It is late, not late in the dramatic sense, no ticking clock, no trench coats, but late in the bureaucratic sense, which is quieter and somehow heavier. The kind of late where the building has stopped pretending it is alive. The kind of late where the air itself seems to have settled. The room is rectangular and practical and unremarkable, which is exactly the point. Government buildings of the mid-1980s were not designed to inspire awe. They were designed to endure. Beige walls, industrial carpet that absorbs sound rather than reflects it. Fluorescent lights that hum softly, not quite flickering, not quite steady. The kind of light that makes everything look a little tired. On the desk, a stack of paper that has weight to it. Real weight. Thick, fibrous paper, manila folders, some of them tabbed, some of them stamped. Ink that has soaked in rather than sat on top. A rubber stamp nearby, its handle worn smooth from use. Red ink, always red, confidential. Yis only, do not duplicate. The font matters. It always does. This is not sleek modern typography. This is utilitarian. Block letters, all caps. Designed to be read quickly, to leave no ambiguity about authority. The kind of font that does not invite questions. There is a chair across the desk, but no one is sitting in it now. Whoever sat there earlier has already left. Their coffee cup ceramic, chipped at the rim, is still warm enough to give off a faint smell. Burnt, maybe, or just old. The clock on the wall says a few minutes past 9, but the second hand ticks with the confidence of a device that does not care who is watching. This is a federal office in the United States, sometime in the latter half of the Cold War. The exact city does not matter. The exact agency does not matter. What matters is that this room exists because thousands like it exist. What happens here is not unique. That's the unsettling part. On the desk is a case file that has been open for a long time. Not open as in unresolved, although that, too, but open as in physically open. The folder lies flat, its metal fasteners bent back, the stack of documents inside slightly uneven, as if it has been handled more than once, put down and picked up again, never quite aligned the same way twice. This is how paper tells time, not with timestamps or metadata, but with where. There are memos in the file, typed memos. You can tell by the spacing, by the way the letters are not perfectly uniform, by the faint impressions left on the page beneath. Someone pressed hard on the keys. Someone was thinking while they typed. You can see it in the rhythm of the sentences, short, declarative lines interrupted by longer explanations that try politely to anticipate objections. There are interview summaries, names at the top, dates in the margins, initials at the bottom. There are photocopies of things that were photocopies even then. Bank statements, receipts, letters. The copies are slightly crooked, the edges shadowed, because that is what photocopiers did in the 1980s. They reminded you that this was not the original. That this was a copy of something that lives somewhere else, and then there are the redactions. Not digital redactions, not the clean rectangular black boxes we are used to now. These are physical redactions, tape, opaque strips laid carefully over lines of text. Sometimes black marker, pressed down hard enough that it bleeds through the page, leaving a ghost of the words beneath. Sometimes scissors, actual scissors, used to remove entire paragraphs, leaving a jagged absence where information used to be. It is one thing to see a redaction on a screen. It is another thing to hold one in your hands, to feel the thickness where tape overlaps paper, to see where someone made a decision by hand to make sure you could not read what was there before. Someone in this room is reviewing the file one last time. You can tell it is the last time because of the posture, the way they sit back slightly, not leaning forward anymore, the way the pen rests on the desk rather than being held, the way the pages are no longer being flipped, just looked at. This is not discovery, this is assessment. There is a form on top of the folder, a routing sheet, boxes checked, signatures added, dates filled in. The handwriting is different from line to line, which tells you how many people have touched this file, how many desks it has sat on, how many rooms like this one it has passed through. One of the boxes near the bottom is labeled with language that is deliberately vague, not solved, not closed, something softer, something procedural, administrative disposition. That phrase does a lot of work. It sounds neutral, technical, almost comforting. But what it means in practice is this: no more active steps will be taken. No new interviews scheduled. No new subpoenas requested. No more resources allocated. The file will not be destroyed. That is important. Destruction is an act. Destruction leaves a mark in the logbooks. This is not destruction. This is shelving. The file will be boxed. The box will be labeled. The label will include a case number, a date range, and a brief description that is accurate enough to satisfy the rules and vague enough to avoid curiosity. The box will be sent to a records facility, maybe in the same state, maybe not, where it will be placed on a shelf alongside thousands of others, temperature-controlled, humidity-controlled, access-controlled, time-controlled too, in a way. Because, in government, time is not just something that passes. Time is something that can be managed, deferred, extended, used. The person in the room signs their name at the bottom of the routing sheet. The pen makes a soft scratching sound. The ink dries quickly. They pause for just a moment, looking at the file as if weighing something. Then they close it. The metal fasteners snap back into place. The folder is squared up, edges aligned, made neat again. There is no dramatic music here, no sense of finality. Just the quiet competence of a system doing what it has been designed to do. And this is the part that matters, because files like this do not disappear, they persist. They exist in a kind of suspended state, neither alive nor dead. They can be reopened, they can be reclassified. They can be requested. They can be released, sometimes partially, sometimes fully, sometimes in ways that raise more questions than they answer. In the decades after this file is shelved, the world will change. Computers will replace typewriters. Digital databases will replace filing cabinets. Redactions will become cleaner, more precise, more uniform. But the underlying logic will remain the same. Information is gathered, information is evaluated, information is controlled. And sometimes, the most consequential decision is not what to investigate, or even what to conceal, but what to leave unresolved. What to allow to sit quietly in a box, waiting for a moment that may or may not ever come. In the 1980s, no one in this room can see that future moment. They are not thinking about public records requests or transparency laws or digital uploads. They are thinking about process, about precedent, about whether everything that needs to be done has been done enough to justify stopping. The clock ticks, the lights hum, the building settles a little more. The box is taped shut, and the file, this thick, complicated, unfinished file, enters a long sleep. Not forgotten, just filed. Right. And the reason that matters now. There is a particular sound that only exists in courthouses and government buildings. It is not loud. It is not dramatic. It is the sound of doors opening and closing all day long, heavy doors with hinges designed to last decades, punctuated by the faint echo of footsteps and the low murmur of people who know they are being recorded somewhere, somehow. In December of 2025, that sound accompanies a new entry on a federal docket. Not a splashy one, not a midnight filing, just a timestamp, a document number, a PDF uploaded to a system designed to be boring on purpose. Pacer does not care how important you are. It cares that your margins are correct. And the reason that matters now is because of what just hit the court docket. To understand why this moment lands the way it does, you have to slow down. You have to read not just the filing, but everything around it, the emails that led to it, the internal memos that predate it, the conversations that happened in offices that look an awful lot like the one we just left. Different decade, same fluorescent lights. Start with the law itself. In November of 2025, the president signs a piece of legislation with an unusually direct name, the Epstein Files Transparency Act. The title is not poetic. It is not subtle. It does not pretend to be about administrative reform or procedural harmonization. It says exactly what it is meant to do. Inside the Department of Justice, that name lands with a thud, because names like that create calendars. Within days of the signing, there are internal DOJ emails, procedural, careful, unmistakably lawyerly, circulating between divisions. These are not ideological emails. They are logistical. Who has custody of what? Which components hold responsive records? How many pages are we talking about? What counts as unclassified? What counts as reasonably segregable? Those phrases matter. They are not filler. Reasonably segregable is the language of redaction. It is the space between what the public is entitled to see and what the government believes it is obligated or allowed to withhold. In one memo, the tone is almost studious. The law requires release by a date certain, December 19, 2025. There is no ambiguity about the deadline. There is also no ambiguity about the exceptions. Victim privacy, ongoing investigations, national security, though, that last one is raised cautiously, almost as an afterthought. Another memo, this one from a different office, flags volume, hundreds of pages at least, possibly thousands. stored across multiple systems, some digitized, some not, some scanned years ago, crooked and grainy, others crisp, newer, annotated electronically. There is a meeting. There is always a meeting. Conference room, long table, bottled water untouched. Someone has printed out the statute and highlighted it in 3 different colors. Someone else has brought a binder old habit, despite the fact that everything is on a shared drive now. Titles are used. First names are not. The conversation is not about whether to comply. That question is already answered. The conversation is about how. What constitutes compliance? Is release the same as disclosure? If a document is technically released but substantively unreadable, does that satisfy the statute? These are not rhetorical questions in the room. They are real ones. Asked quietly, answered cautiously, deferred when necessary. A lawyer points to a paragraph in the law. Another lawyer points to a footnote in a prior court opinion about redactions. Someone reminds the room that Congress is watching this one closely. Someone else reminds the room gently that Congress always watches at first. By early December, the work becomes mechanical. Teams are assigned, files are pulled, redaction software is opened, checklists are created. Each document is reviewed not once but multiple times. Substantive review, privacy review, final sign-off, and still, the clock moves. December 19 arrives not with a bang, but with an upload. On the Department of Justice website, a page appears. Links, file names, page counts. The public-facing explanation is straightforward. These are the documents released pursuant to the Epstein Files Transparency Act. Journalists begin downloading immediately. So do lawyers. So do members of Congress and their staffs. The PDFs open slowly. Some are large. Some are scans of scans. The first thing everyone notices is not what is in them, but what is not. Redactions, heavy redactions, entire pages where the only visible text is the page number. Paragraphs reduced to black bars. Names removed so completely that it is impossible to tell how many names were there to begin with. This is where the conversations outside the building start. Reporters compare notes. One notices that a document referenced in an index does not appear in the release. Another realizes that a page jumps from 12 to 27 with no explanation. Someone else spots a photograph embedded in a file that seems out of place, and then, later, cannot find it again. Inside the DOJ, there is another meeting, because something has gone wrong, or at least something has been noticed. 16 files, identified by their file names, their upload timestamps, their URLs, are no longer accessible. They were there, then they weren't. The server logs confirm it. This is not a browser glitch. This is not user error. The internal conversation is brisk now. Technical teams are looped in. Was this intentional? Was this a security issue? Was there a problem with the upload batch? No one notably says, this is fine. By the end of the day, the files are restored, quietly, without a press release. Without an explanation beyond a general assurance that the department is committed to compliance and transparency. That assurance is not received the way it might have been, say, 10 years earlier. On Capitol Hill, staffers are pulling the statute back out, reading it again, line by line. They are comparing what the law says to what has been released. They are drafting letters. Some are polite, some are less so. One letter, circulated for signatures, uses a phrase that does not appear in the statute but carries weight all the same: facial noncompliance. That phrase means this: you don't have to know what's behind the redactions to know that something is off. The absence itself is evidence. The Attorney General's office issues a statement, carefully worded, emphasizing victim protection, emphasizing legal obligations, emphasizing the unprecedented nature of the release. None of that quiets the central question, which is now being asked out loud on camera by people with gavels. If this is everything, why does it feel like we're still being shown so little? This is the pivot. Not from past to present in a metaphorical sense, but from institutional habit to public confrontation. From files that could sleep quietly on shelves to files that now live in the open, where their omissions are visible to anyone with a PDF reader and a little patience. Because once documents are released, even partially, they stop belonging solely to the people who filed them. They become something else. They become evidence of process, evidence of judgment, evidence of where the lines are drawn. And suddenly, that old decision, the one made in a quiet room, under humming lights, with a pen scratching out a signature, doesn't feel so distant anymore. It feels immediate. It feels unfinished. And it feels like the beginning of something that was supposed to be over. Right, wait for it. W.H. the law actually said, reading the fine print out loud, There is a moment in every high-stakes legal story when the drama drains out of the room and all that's left is paper. Just paper. Words, sentences that look inert until you realize they are doing almost all of the work. Very specific things, and it says them in a way that leaves a trail. Inside the Department of Justice, the first serious conversations about compliance do not start with strategy. They start with reading, not skimming, not summarizing, reading. In one office, a senior attorney prints the statute single-sided, even though double-sided would save paper. This is deliberate. Margins matter, space matters. You need room to write. The title sits at the top of the first page, centered, formal, an act to require the disclosure of certain records relating to Jeffrey Epstein and for other purposes. No adjectives, no hedging, just a directive. Someone underlines require. In another office, the same statute is open on a screen. The scroll bar is tiny because congressional drafting is not known for brevity. A junior attorney highlights as they go, color-coding instinctively, yellow for mandatory language, blue for exceptions, pink for definitions. Mandatory language fills the page. The Attorney General shall release, not may, not endeavor to, shall. That word triggers an email almost immediately. Subject line, statutory obligations, Epstein files, act. The body is short, almost curt, as drafted. This creates a non-discretionary duty. Deadline is fixed. We should assume strict scrutiny. Strict scrutiny. Another phrase that does a lot of work. A meeting is scheduled. Calendar blocks appear. 30 minutes becomes an hour. An hour becomes 90 minutes. Someone adds prep time beforehand, which is code for this is not going to be simple. In the conference room, the statute is projected on a screen. No PowerPoint, just the text, section by section, subsection by subsection. Someone reads aloud, because reading aloud forces you to confront the sentences you might otherwise glide past. Not later than 30 days after the date of enactment, that date is circled, then circled again, then written in the margin as a standalone note, DEC 19. Deadlines like that are not flexible. They do not care about workload. They do not care about holidays. Another attorney interrupts the reading, not to argue, but to clarify. Can we pause on unclassified? Because that word appears early and often, unclassified records. The statute is explicit. Only unclassified records are covered. That seems straightforward until you remember that classification is not binary. There are layers, there are legacy documents, there are materials that were never formally classified but were treated as sensitive anyway. Someone flipped to a memo they brought with them, a DOJ guidance document from years earlier, outlining how to handle records that are functionally sensitive but not formally classified. That memo predates this law. It was written for a different purpose. But here it is being pressed into service because institutions reuse their own logic. Another line is read aloud, including records that were previously withheld, in whole or in part. That line lands hard because that means prior decisions do not control this one. The fact that something was once withheld does not, by itself, justify withholding it again. There is a silence after that sentence. Then someone asks the question that is hanging in the room. So we're relitigating old redactions. No one answers immediately. Instead, another section is read. Except that the Attorney General may redact information necessary to protect the privacy of victims. There it is. The exception. Narrow, specific, emotionally powerful. No one in the room argues with it. But exceptions are where the work happens. How broadly do we define necessary? What constitutes privacy in records that are decades old? Are names alone enough, or do contextual details count? Each question spawns another email. Each email spawns another memo, not dramatic memos, dry ones. Headings like scope of permissible redactions and balancing test. Victim privacy vs. public interest. One memo cites prior FOIA cases. Another cites legislative intent. Someone else quotes from the floor debate in Congress, where lawmakers spoke about sunlight and accountability and closure. Legislative intent is persuasive, not binding, but it is still read. Carefully, there is a separate subsection on ongoing investigations. This one is read even more slowly because ongoing is a slippery word. Ongoing where? Ongoing how? Ongoing in fact or ongoing in theory. A lawyer points out that an investigation can be technically open without being active. Another lawyer counters that courts have historically deferred to agencies on this question. A third lawyer notes that deference erodes when statutes are explicit. Someone writes in the margin, risk our aria. By the end of the meeting, the statute is covered in ink arrows, notes, question marks. Someone has written simply, "This will be litigated." After the meeting, the conversations continue in hallways, in offices, in emails sent late at night with subject lines like quick thought and one more thing. One email asks whether metadata counts as part of the record. Another asks whether images embedded in documents trigger separate review standards. A third asks, almost sheepishly, whether releasing something once means you can't take it back. That one does not get a direct answer. Instead, it gets forwarded up the chain. Because this law, as written, does not give a lot of room to hide. It gives instructions, it gives deadlines, it gives exceptions that are narrow enough to be defensible only if used carefully. And that is the tension running through every conversation, careful versus complete. In one final preparatory memo, circulated just days before the deadline, someone tries to summarize the task ahead. The language is cautious, almost restrained. Our obligation is to maximize disclosure consistent with statutory limitations. Maximize disclosure. That phrase is underlined by the recipient twice, because maximizing disclosure is not the same as full disclosure. It is a standard that invites interpretation. It asks how much is enough. And here is the thing about laws like this. They are written for moments of mistrust. They are passed because someone somewhere decided that the normal processes were not sufficient, that sunlight had to be compelled, not requested. So when a law like this says shall, it is not being poetic, it is being corrective. Every memo, every meeting, every careful conversation about commas and clauses, all of it flows from that choice to write a law that does not trust the system to decide on its own. And that is why this chapter matters. Because before we ask what was released, or what was missing, or why something went dark and then reappeared, we have to sit with the words that set all of this in motion. Not the headlines, not the talking points, the text, the unglamorous, densely drafted, deeply consequential text. Right. 700 pages, arriving all at once. The release does not happen with a press conference. There is no podium, no seal behind it, no senior official stepping forward to frame the moment. The Department of Justice does not do spectacle unless it has to. This is not one of those times. The release happens the way government prefers things to happen, quietly, digitally, with a timestamp. It is early in the day, Eastern Time, when the files appear on the DOJ website. A new page, a familiar layout, blue hyperlinks stacked vertically. File names that read like inventory rather than narrative. No adjectives. No explanation beyond a short paragraph stating that these materials are being released pursuant to the statute. Inside the building, the mood is not celebratory. It is procedural. Weeks earlier, long before anyone outside the department refreshes a web page, there are final memos circulating. These are not about interpretation anymore. Those arguments had been had. These memos are about execution. One memo, marked for now, for release, lists the contents of the tranche. Page counts next to document IDs. Check marks in a column labeled Reviewed. Initials in another column labeled Cleared. Every initial matters. Every checkmark represents at least one set of eyes, sometimes more. Another memo addresses sequencing. Should everything go up at once or in batches? There is brief discussion of server load, of public access, of whether staggered releases invite suspicion. The consensus, such as it is, lands on simultaneity. All at once, someone writes in the margin. Cleaner. There is an IT meeting, not glamorous, fluorescent lit. Someone dials in remotely because they are already home, and it is late. The agenda is technical, file size limits, link stability, backup mirrors. Someone asks what happens if a file fails to upload. We'll know, comes the answer. There will be logs. Logs are comforting. Logs mean traceability. As the deadline approaches, the conversations get shorter, less philosophical, more operational. One email goes out to a distribution list with a subject line that is almost aggressively neutral. Release timing confirmation. The body is 3 sentences long. It confirms the date. It confirms the time window. It confirms that no further changes are anticipated. No further changes is not a guarantee. It is a hope, because up until the very last moment, there are still decisions being made. Redaction boxes adjusted by a few pixels. A name removed here, a date there. Someone notices that one document references an exhibit that is not included. Is that a problem? Is the exhibit itself subject to release? Has it already been released elsewhere? There is a quick consultation, then another. Someone pulls an old memo, someone else checks the statute again. Ultimately, the decision is made to proceed. By the time the files go live, most of the people who worked on them are no longer watching. They have moved on to other things. That is how bureaucracy survives, by not lingering. Outside the building, though, people are very much watching. Journalists download the files in bulk. Lawmakers, staffers do the same. Advocacy groups begin parsing immediately. The PDFs open slowly, one after another, like doors that are heavier than you expected. The first reaction is not outrage, it is confusion. Page 1 opens to a title page, mostly intact. Page 2 is entirely blacked out except for a footer. Page 3 has text, but the names are gone. Page 4 is a scan so dark it looks like it was photocopied in a basement. A reporter scrolls back up, checks the page count. 700 pages. Okay, they say, out loud to no one. Someone else notices that the redactions are not uniform. Some are thick, opaque rectangles. Others are thinner, almost translucent at the edges. Different tools, different times, different hands. Within minutes, people begin comparing notes. Are your pages numbered the same way? Do you have text on page 1114? Is this section supposed to connect to the next one? Patterns emerge quickly, or rather absences do. Entire sections appear to be missing. Not redacted missing, not redacted missing, page numbers jump. References go unanswered. A memo mentions an attachment that is nowhere to be found. Inside the DOJ, alerts start pinging, not from the public, from the system itself. One file did not render correctly. Another link points to the wrong document. A third returns an error message. These are not catastrophic problems. They are the kinds of things that happen when you upload hundreds of pages at once, but they matter because now the release is being watched frame by frame. There is a call, IT, records, legal, a quick triage, which errors are cosmetic, which affect substantive access. Someone flags a list. 16 files, they were part of the release batch, they were verified, they were uploaded, and now they are not accessible. This is not immediately obvious to the public. It takes time for someone outside to notice, but inside, the logs make it clear. There is a pause. Then the questions start. Were these files pulled intentionally? Were they miscategorized? Did someone apply the wrong permissions? No one answers right away because no one knows yet. Another call. This one includes supervisors. The tone shifts, not panicked, but alert. Someone asks whether these files contain anything materially different from the rest. Someone else asks whether pulling them could be construed as altering the release after the fact. That question hangs in the air, because intent matters, but appearance matters too. Within hours, the decision is made to restore the files, quietly, no announcement, no explanation beyond a general statement if asked. When the files reappear, someone inside the department sends a short email, resolved. That is the entire message. Outside, the restoration does not calm things. It sharpens them, because now people are looking not just at what is redacted, but at what flickered in and out of existence. Screenshots circulate, URLs are archived, comparisons are made between versions. Inside the DOJ, another memo is drafted. This one is defensive in tone, though it does not use that word. It outlines the release process. It emphasizes the unprecedented scope. It reiterates the statutory exceptions. It frames the redactions as careful, necessary, legally required. The memo is not wrong, but it is not persuasive. On Capitol Hill, staffers are now working with printouts. Old school, highlighting, sticky notes. One staffer circles a redacted paragraph and writes in the margin, "Why this?" Another writes, "Missing." Questions become lists. Lists become letters. One draft letter is particularly blunt. It notes that while the statute required release, what the public received was a volume of obscured material that frustrates, rather than fulfills, congressional intent. That phrase, frustrates congressional intent, is underlined 3 times. Inside DOJ leadership meetings, the temperature rises slightly, not to a boil, but enough to notice. Someone says, "We complied." Someone else says they don't think we did. Those two statements coexist uncomfortably, because compliance is not just a legal conclusion, it is a political one, a public one. And now the release, this drop, this carefully prepared, heavily reviewed drop, is being treated not as an endpoint, but as evidence. Evidence of how much was withheld, evidence of how decisions were made, evidence of where the black ink fell. And this is the thing about documents. Once they are released, they stop being inert. They start being read against the grain, compared, contextualized, challenged. The drop was supposed to close a chapter. Instead, it opened a new one. Right. The disappearing files, 16 files. Gone. It starts the way these things always start now, not with a phone call, not with a knock on a door, but with a refresh. Someone refreshes the page. They had been scrolling through the list of files, opening them one by one, doing the quiet, methodical work that has become second nature to anyone who reads government releases for a living. Click download, open, scroll, close, repeat. Then instinctively, they scroll back up. Because something feels off. The list looks shorter, not dramatically shorter, not in a way that jumps out at you if you're casual about it, but if you've been counting, if you've been tracking file names, timestamps, page counts, there's a gap, a subtle one. The kind that only registers if you've already built a mental map of what's supposed to be there. They scroll again, slowly, still missing. Inside the Department of Justice, no alarms have gone off yet, not the loud kind anyway. There is no klaxon for public confidence issue. There are only dashboards and logs and quiet indicators that something somewhere has changed state. In a small IT office windowless, humming with servers, someone notices an access anomaly, a routine check, a list of files with permissions toggled differently than expected, 16 entries. They pull the list. File names, upload times, sizes, all part of the same batch, all marked as previously accessible, now marked otherwise. They send an email. Subject line, access check, released files. The body is careful. Noticing a discrepancy in public accessibility for a subset of released documents, investigating whether this is a permissions issue or intentional modification. Intentional modification. That phrase is doing a lot of hedging, because if it is a permissions issue, it is technical, fixable, mundane. If it is intentional, it is something else entirely. The email goes to a small group at first. IT, records. One attorney who has been looped into technical questions before. Within minutes, it is forwarded upward. There is a call, not scheduled. Just a, can you jump on for a minute? Call. Cameras off. Voices low. Everyone knows this is sensitive, but no one knows yet how sensitive. Can we confirm they're actually gone? Someone asks. They're not visible publicly, comes the answer. They still exist in the system. That distinction matters. Not deleted, not destroyed. Just not visible. Another question follows quickly. Do we know what's in them? There is a pause, because everyone knows what's in them. In the broad sense, they've been reviewed, cleared, redacted, logged. They're not mysteries. But one of them contains an image. One of them contains an image. An image that people outside the building will recognize instantly if they see it referenced. An image that even redacted carries weight simply by existing. That fact is not spoken out loud on the call. It doesn't have to be. Everyone on the line already knows which file it is. Someone clears their throat. Was there any directive to pull these? Silence, not the awkward kind, the confirming kind. No, someone says finally, not from us. That answer narrows the field. Now the questions sharpen. Was there a late-stage legal concern? Was there a privacy reassessment? Did someone decide after release that these files crossed a line? If so, where is the paper trail? Because decisions like that generate paper. Memos, emails, at the very least, a note in a log. There is nothing. Another call is added. This one includes a supervisor. The tone is still controlled, but the stakes are clearer now. Let's walk through the possibilities, the supervisor says. Technical error, human error, or intentional restriction. Those are the options. They take them one by one. Technical error possible. Large batch upload. Permissions propagate incorrectly. It happens. Human error, also possible. Someone toggled a setting without realizing the impact. Intentional restriction, possible but unlikely without documentation. No one wants it to be the third option, not because of guilt, because of optics. Outside the building, the noticing accelerates. A journalist posts a screenshot on social media, side by side, before and after. File names highlighted, circles drawn. The caption is short, almost understated. Am I losing it or are these gone? Replies pile up. I saw that too. Same here. Checked archive.org was there earlier. Now it's not just one person, it's a chorus. Inside Docket, the call turns into a working session. Can we restore visibility immediately? Yes. Do we need approval? That depends. Depends on what? Depends on whether restoring them could be construed as acknowledging a mistake. Depends on whether leaving them down could be construed as something worse. Someone suggests drafting a statement preemptively, just in case. Another pushes back. Let's not create a story if we don't have to. but the story is already forming. Because absence is loud, the supervisor makes a call, not a group call, one-on-one, up the chain. They explain the situation carefully, neutrally, emphasizing uncertainty and urgency. The response is brief: fix it. That is all. No qualifiers, no caveats, no caveat. Within the hour, the permissions are restored. The files reappear. The links work again. If you weren't looking closely, you might never know they were gone. But people were looking closely. Screenshots are reposted. Timelines reconstructed. Someone notes the exact window, how long the files were inaccessible. Someone else points out that restoration without explanation raises as many questions as removal. Inside DOJ, a short internal note is circulated. Issue identified and resolved. It lists the time of the discrepancy, the number of files affected, the corrective action taken. It does not speculate on cause. It does not apologize. It does not explain. That omission is not accidental. It is institutional instinct. You do not speculate in writing about unresolved causation, but outside speculation fills the gap. Was this a test? Was this a pullback? Was this someone realizing too late what had been released? On Capitol Hill, staffers take note. Literally, one staffer adds a bullet point to an already growing list: temporary removal of released documents post-deadline. Another staffer circles the bullet and writes, "Ask about this." Inside the DOJ, leadership now understands that the release is no longer static. It is dynamic. It is being watched in real time, not just for content, but for behavior. What stays up? What comes down? What flickers? There is a meeting at the end of the day. Not emergency, but not routine either. The question on the table is simple and unsettling. If they notice this, someone says, what else are they going to notice? No one answers right away. Because the truth is, once people start watching for absence, they stop trusting presence. Every redaction becomes suspect. Every missing page becomes intentional. Every technical explanation becomes provisional. The files are back. That part is true. The idea that this was a clean, controlled release, that idea is gone. Now there is a new understanding shared by everyone paying attention. These documents are not just records. They are active. They can move. They can disappear. And if they can disappear once, even briefly, then the question is no longer what did we see? The question becomes what else could vanish? Right. Who touched these files last? If you want to understand how something happens inside a large institution, you do not start with motive. You start with hands, not metaphorical hands, actual ones. Who opened the file? Who annotated it? Who redacted it? Who clicked approve? Who clicked upload? Because in systems like this, nothing happens all at once. It happens in layers, sequentially, quietly, logged. Inside the Department of Justice, after the files flicker gone, then back the instinct is not defensive. It is forensic. They pull the process apart. There is a memo circulated the morning after the restoration. It is not accusatory. It is procedural. The subject line reads like an audit checklist: post-release process review, document handling. The records originate in multiple places: archives, investigative divisions, legacy systems that predate cloud storage. Each custodian signs off that what they provided is complete as held, not complete in some cosmic sense. Complete as in, this is everything we have in this drawer, on this server, under this case number. Those sign-offs are already on file. No issues there. Second stop, compilation. Records are gathered into a working set. File names standardized. Page numbers checked. A master index created. That index becomes a kind of spine for the entire release. If something is missing from the index, it should not exist publicly. If it exists publicly, it should be in the index. Someone pulls the index now and traces each of the 16 files back through it. They're there, logged, properly categorized. No anomalies. Third stop, substantive review. This is where attorneys read for content, not to decide guilt or innocence, but to identify what the law allows to be seen. Names, addresses, sensitive details, anything that could plausibly fall under the statute's exceptions. Each document carries a review stamp digital now, not rubber, and a date. Sometimes 2 dates if revisions were made. The 16 files, reviewed, cleared, dates align. Fourth stop, redaction. This is its own universe. Redaction is not just blacking things out. It is choosing how much to black out. One line versus a paragraph, a name versus a role. Sometimes the context itself becomes identifying, which means entire sections go dark. There is software involved, templates, presets, but there are also human decisions, judgment calls, and those calls are supposed to be consistent. Another memo surfaces, this one written weeks before the release, outlining redaction standards specific to this project. It emphasizes uniformity. Avoid mosaic effect, it says, a term of art meaning that small details, when combined, can reveal something meant to stay hidden. That memo is reread now with different eyes. Fifth stop, quality control. This is the final pass. Someone who did not do the initial review checks the work, page counts, redaction consistency, file integrity. It is meant to catch errors before they escape. According to the logs, QC happened. The checkboxes are marked. The timestamps are there. Sixth stop, authorization. This is where the release becomes official. A supervisor signs off, sometimes more than one. Their names are not public, but their approvals are recorded. This step is not about content anymore. It is about risk. Once authorized, the files move from internal to public. Seventh stop, publication. This is the handoff to IT, files uploaded, permissions set, links generated, backup copies stored, and here is where the trail narrows. The IT logs show something subtle, not dramatic, not a deletion. A permissions change, a toggle, a setting applied to a subset rather than the whole. 16 files. The memo describing this does not speculate on why. It only notes when. The timestamp is after the initial release, which means whatever happened post-authorization. There is a follow-up meeting. This one is more technical. Screens are shared. Log files scrolled. Someone points to a line of code and says, that shouldn't have applied to these. Another person responds, unless it was inherited from the parent folder. Inheritance. Another technical term that suddenly carries weight. If a parent folder's permissions change, everything inside can change with it, unless explicitly exempted, so someone changed the parent. Someone asks, possibly comes the answer, or created a new one and moved files. That raises another question. Who has access to do that? A list is generated, not long, fewer people than you might think. Access is restricted by design. The names on the list are not read aloud in the meeting. They don't need to be. Everyone present knows them. The conversation shifts tone, not accusatory, but cautious. This is where process meets trust, because process assumes good faith. It assumes that people follow the rules because the rules are there. But trust is what fills the gaps between logged actions. Another memo is drafted, this one explicitly internal, explicitly non-public. It recommends changes, more granular permissions, additional sign-offs for post-release modifications, a freeze protocol once documents go live. In other words, the system needs guardrails it didn't have before. Someone asks the question no one wants to ask out loud. Do we need to notify Congress about the process failure? The word failure lands hard. A lawyer responds carefully. We need to be precise about what failed. The files were restored. The content did not change. The access interruption was brief. Is that a failure or a glitch? That debate does not resolve itself in the room. It gets deferred again to leadership. Outside the DOJ, none of this nuance is visible. What is visible is that the files moved. That access was altered. That something behind the scenes was less stable than advertised. Inside, the realization sets in that the process, this elaborate, multi-step, carefully designed process, worked exactly as designed right up until it didn't. And that is the most unsettling outcome of all. This didn't happen because the system was broken. It happened because the system allowed it. Right. Congress loses its patience. When process stops being an answer, Capitol Hill has its own soundscape. It is different from the hum of federal office buildings, different from the click of keyboards and the low whir of servers. This is a place of voices, raised, lowered, overheard. Of paper being slid across desks. Of staffers speaking in half sentences because time is always being borrowed from something else. By the time the disappearing files are restored, patience on the Hill is already thinning, not snapping, not exploding, thinning, and there is a difference. It starts with emails, staff to staff, committee to committee, subject lines that look innocuous to anyone outside the ecosystem but land heavily inside it. Aventura, Re-DOJ Epstein release. Initial review flagging issues for member compliance questions in one office. A senior staffer prints the statute again. This is the third time this month. The pages are already dog-eared. They add the DOJ's release documents to the pile, clipped together with a black binder clip that is barely strong enough to hold them. They do not read them like a story. They read them like a contract, page by page, line by line, with the statute open beside them. A junior staffer notices something first, not the redactions themselves, but the pattern of them. Entire sections redacted where others, structurally similar, are left partially visible. Why would this paragraph be fully blacked out, they ask, but this one isn't? No one answers immediately. Because there is no obvious answer, another staffer has been tracking the release in real time. They have screenshots, time-stamped. They show the file list before and after the disappearance. They don't editorialize. They just lay them side by side. That, they say, tapping the paper, is going to be a problem. Within days, draft letters begin circulating. One draft is careful, almost diplomatic. It acknowledges the complexity of the task. It thanks the department for its efforts. It then asks, politely, for clarification on the scope of redactions and the temporary removal of files. Another draft is less patient. It uses words like concerned and deeply troubling. It cites the statute directly. It notes that the law did not contemplate post-release modification of access. A third draft, this one clearly not meant to be the opening salvo, includes a phrase that makes everyone sit up straighter: potential contempt. That phrase is not used lightly. It is not a threat. It is a procedural reality. Congress has tools. It rarely uses them. But invoking them, even in draft form, changes the tone of everything that follows. Meetings are scheduled. Closed-door briefings. No cameras, no microphones, just members, staff, and representatives from the Department of Justice. Inside one such briefing, the atmosphere is controlled but tense. The DOJ representatives come prepared. They have talking points. They have timelines. They have a clear narrative. Compliance achieved. Unprecedented transparency delivered. Minor technical issues resolved. They emphasize victim privacy. They emphasize legal constraints. They emphasize that no content was altered. A member interrupts. Was access to released documents ever restricted after the statutory deadline? The question is precise. The answer has to be equally precise. Yes, comes the response, after a pause. Briefly, due to a technical issue. Another member follows up immediately. How many? Another pause. 16. That number lands. Were any of those files removed intentionally? No. Were they reviewed again before being restored? Yes. By whom? That question does not get an immediate answer. Not because there isn't one, because naming names in that room carries consequences. A staffer scribbles notes furiously. Someone else circles the word technical in their notes and writes a question mark next to it. After the briefing, the hallway conversations begin. Members talk to members. Staff talk to staff. Phones come out. Messages are sent. One member, known for being meticulous rather than bombastic, asks their counsel a quiet question. Do we have enough here to compel testimony? The counsel does not answer right away. Potentially, they say finally. If the record doesn't improve. The record. That word now matters as much as the documents themselves. Back at DOJ, leadership is aware that the mood has shifted. This is no longer about satisfying public curiosity. It is about satisfying a co-equal branch of government that wrote the law in the first place. A memo is drafted for internal circulation. Congressional Engagement Strategy. Epstein Files Act. The memo outlines next steps, additional briefings, supplemental explanations. Possible further releases if feasible. It also includes a section on risk. Reputational risk, institutional risk, litigation risk. One line stands out. Perception of noncompliance may be as consequential as noncompliance itself. That sentence is underlined by more than one recipient. On the Hill, another letter goes out, this one signed. Bipartisan. That fact is emphasized, quietly but deliberately. It references the statute again. It references the release. It references the temporary disappearance. And then it asks, directly, whether the department believes it has fully complied with the law. That question is not rhetorical. In press statements, members begin to say the quiet part out loud. This is not what we were promised. Transparency means more than posting black boxes. If the department cannot comply, we will consider our options. One name begins to appear more frequently now. Attorney General Pam Bondi, not as a villain, not as a caricature, but as the accountable official, the one whose name sits at the top of the organizational chart. In interviews, members are careful. They do not accuse. They do not speculate. They say things like, the Attorney General owes us an explanation, and this falls under her responsibility. Those phrases are measured, but they are not gentle. Inside DOJ, another meeting. This one includes communication staff, legal staff, leadership. The question on the table is no longer just what happened. It is how much do we say about it. Transparency has become the demand, and transparency has become the risk. Say too little, and Congress escalates. Say too much, and you create new lines of inquiry. Someone points out that contempt proceedings would be unprecedented in this context. Someone else responds, so was the law. That is the moment when it becomes clear. The patience has run out not because of a single redaction or a single missing file. It has run out because the system is now talking to itself. Congress passed a law because it did not trust the normal process. The department followed the process and said, "Trust us." Congress looked at the result and said, "No, that is not a misunderstanding. That is a collision. And once that collision happens, everything changes." Right. Trick release. Without revelation. There is a phrase that circulates in government long before it ever reaches the public. It doesn't appear in statutes. It doesn't show up in press releases. Tussent dime priez. Say, hopes think Dow, see its state is a blacks with a tax trick, which created crosity with a J, and the batch of crosity with it Mac, opportunity of that a revelation time. It lives in conversations, half joking, half serious, between people who have been doing this long enough to recognize the pattern. We complied. Not we told you everything, not we showed you the truth. Just we complied. Inside institutions, that sentence is a shield. It is precise, it is defensible, and it is very, very old. In one DOJ office, as congressional pressure mounts, someone reaches for history, not out of nostalgia, but out of habit. They pull a binder from a shelf, not labeled Epstein, labeled Precedents. This is not a dramatic binder. It is beige, 3-ring. The kind that has been reused so many times the spine is soft. Inside are memos from other moments when sunlight was demanded and carefully rationed. One tab reads, Watergate, tape disclosures. Another, Iran-Contra, document production. Another still, church committee, intelligence records. No one in the room needs a lecture on these episodes. They know them. But revisiting them now serves a purpose. It reminds everyone that the current moment is not unprecedented. It is familiar. They open the Watergate section first. A memo from the early 1970s is photocopied and annotated. It describes the negotiation over presidential tapes. What could be released, in what form, with what redactions. The language is strikingly familiar. Protect ongoing matters, protect sensitive sources, protect institutional prerogatives. Someone points to a handwritten note in the margin copied, not original, that reads, release enough to satisfy demand, not enough to expose everything. No one laughs. The Iran-Contra tab is next. This one is thicker. More memos, more back and forth. It documents a strategy that would become almost canonical: flood the zone, release thousands of pages, let the volume itself become a defense. If everything is available, then nothing stands out. If the public is overwhelmed, attention dissipates. A memo from that era warns explicitly about selective transparency, the risk that releasing too much at once, heavily redacted, can appear cooperative while still concealing key facts. Someone in the present-day room reads that line aloud. That's uncomfortably on point, they say. There is a pause, because this is the moment when the uncomfortable recognition sets in. What is happening now looks an awful lot like what has happened before. On Capitol Hill, a parallel conversation is unfolding. In a committee office, a senior counsel is briefing a member. Not on the specifics of the files, they've already gone through those, but on the strategy. This is a classic move, the counsel says. They're not refusing. They're complying in a way that preserves maximum control. Same thing Congress always does when this happens. We escalate. Escalation is not emotional. It is procedural. Hearings, subpoenas, testimony under oath. Back at DOJ, another memo circulates. This one is shorter, tighter. It is about messaging. Historical context, transparency demands. The memo notes that prior administrations across parties have faced similar pressures. It frames the current situation as part of a continuum, not an aberration. This framing is strategic. If this is normal, then it is defensible. If this is routine, then outrage seems misplaced. But the memo also includes a warning. Historical analogies cut both ways. That line is underlined by the recipient, because Watergate did not end with compliance memos. Iran-Contra did not resolve itself quietly. The church committee did not accept partial answers. Those episodes ended with exposure, not because institutions volunteered it, but because pressure mounted until the old trick stopped working. Another meeting. This one includes someone who has been at DOJ long enough to remember earlier fights over disclosure. They speak slowly, deliberately. This always feels controllable at first, they say. It never is. Someone asks what they mean. I mean that once Congress decides the process itself is the problem, the content stops being the main issue. That lands, because up until now, DOJ has been defending the content of the release, the redactions, the exceptions, the technical glitch. But Congress is no longer focused solely on content. It is focused on behavior. Why were these decisions made? Who made them? What else has been withheld in the name of compliance? That shift is dangerous territory for any institution. Another historical parallel surfaces, this one more recent. FOIA litigation, cases where agencies technically complied with requests while rendering documents effectively useless. Courts eventually push back. Judges use phrases like bad faith and constructive withholding. Those phrases are not accusations yet, but they are precedents. Inside DOJ, someone suggests a proactive move. What if we do a supplemental release, they ask. Show good faith. The suggestion is met with caution. What if that creates more questions? Someone counters. What if it looks like we're admitting the first release wasn't enough? This is the trap of the old trick. Once you play it, you are committed. Any deviation looks like confession. Any pause looks like concealment. On the Hill, the rhetoric sharpens slightly, not dramatically, just enough to be unmistakable. This is not transparency, a member says. This is choreography. That word choreography travels. It appears in op-eds, in think pieces, in quiet conversations between staffers who have seen this dance before. Inside DOJ, the binder is closed. The lesson is clear even if no one says it out loud. Institutions have always believed that managing disclosure is a way to manage consequences. That if you release information carefully enough, slowly enough, partially enough, you can control the story. History suggests otherwise, because the old trick works until it doesn't. And once people recognize it for what it is, the demand changes. It's no longer show us something, it becomes show us everything. Right. What we still don't know, the negative space. There is a moment in every investigation when the documents stop answering questions and start asking them. It happens quietly, not when something explosive appears, not when a name jumps off the page, but when the reader realizes they are staring at a shape cut out of the record. Absence. On Capitol Hill, this realization begins not with outrage, but with spreadsheets. Staffers create matrices, columns for document titles, rows for release status, color coding for redaction levels. Green for minimally redacted, yellow for partial, red for full blackout. There is more red than anyone expected. One staffer notices that entire categories of material appear to be missing, not redacted, not summarized, just not there. Where are the internal routing memos, they ask. Another staffer scrolls through the DOJ index again. Where are the communications between field offices and main justice? What about correspondence with external agencies? What about financial intelligence referrals? Each question is logged, each absence noted. This is not speculation. This is inventory. In a different office, a former federal prosecutor, now a committee counsel, reads the release materials with a different lens. They are not looking for scandal. They are looking for workflow. Every investigation leaves a paper trail, even the most sensitive ones. Especially the most sensitive ones. There should be intake memos, there should be declination analyses, there should be emails discussing scope. Some are there, many are not. They draft a memo. Subject, observe gaps in DOJ Epstein files release. The memo is careful, it does not accuse. It lists categories of documents that would normally exist in an investigation of this size and duration. It notes which categories are underrepresented or absent. At the bottom, a single sentence, the absence of these materials limits Congress's ability to assess compliance. That sentence is the key. Back at DOJ, a parallel conversation is happening, but with a different tone. A senior official asks a pointed question in a closed meeting. What exactly are they asking for now? A staff attorney answers. They're not asking for more documents yet, they say. They're asking why certain kinds of documents aren't there at all. That is a harder question, because redactions can be justified, technical glitches can be explained, but absence suggests a decision either not to release or not to include. Another attorney points out that some materials may fall under exemptions: grand jury secrecy, ongoing investigative sensitivities, victim privacy. All true. But another voice in the room pushes back. Then why aren't those exemptions being cited explicitly? Silence. Because the release, as it stands, often does not say why something is missing. It simply is, and that ambiguity is fertile ground for suspicion. On the Hill, members begin to receive constituent questions that are more sophisticated than expected, not who's in the files, but why are there gaps in the timeline? Why does the record jump from year to year? Why do we see summaries without underlying exhibits? This is what happens when the public gets access to primary source material. They learn how to read it. A member mentions this in a caucus meeting. We ask for transparency, they say. Now people are doing analysis. That is not said as a complaint. It is said as a warning. Another letter is drafted, this one narrower than the others. It does not demand more documents. It asks for explanations. Why are certain document classes absent? What criteria were used to determine inclusion? Were any responsive documents withheld in full without notation? The DOJ response takes time. When it comes, it is technical, dense, carefully worded. It explains categories. It references statutory limitations. It emphasizes that the department exercised discretion consistent with long-standing policy, but it does not answer everything. In the margins of the response, staffers scribble notes. Doesn't address X. Vague. Who made the call? The last question appears again and again. Who made the call? Because absence is not neutral. It is the product of judgment, and judgment implies a decision maker. Inside DOJ, another internal memo circulates, this one flagged as sensitive. Subject: anticipated oversight lines of inquiry. It lists likely questions from Congress. Many of them focus not on what was released, but on what was not. The memo advises consistency, stick to process, avoid speculation. One line stands out: do not characterize withheld materials beyond established exemptions. That instruction is defensive, because characterization invites follow-up. In a televised interview, a member is asked whether they believe the department is hiding something. They pause. I believe there are unanswered questions, they say. And unanswered questions are exactly why Congress wrote this law. That answer is measured, but it shifts the frame. This is no longer about mistrust. It is about mandate. The law did not ask for a curated narrative, it asked for records. And now the question is whether the record presented is complete enough to fulfill that mandate. Late one evening, a staffer sends an email to their supervisor. Subject line: negative space in the body. They write, I keep coming back to what isn't here. The silences, the jumps. It's like reading a transcript with entire speakers missing. The supervisor replies a few minutes later. That's because you're reading around decisions. That insight spreads. Because once you start seeing decisions instead of documents, the investigation takes on a different character. It is no longer just forensic, it is institutional. What we still don't know is not a list of names or events. It is the answer to a more fundamental question. Who decided what the public gets to see, and why? Until that question is answered, every redaction invites interpretation. Every gap invites theory. Every absence becomes a story. And that is the paradox of partial transparency. The more you show, the more the missing pieces matter. Right. The file that never stops talking back in the room where the story began, the one from decades ago, with the heavy furniture and the hum of a government building settling into night, the file never actually closed. That is the part people forget. The mystery that opened this braid was never solved by revelation. It wasn't resolved by confession or disclosure or a dramatic unveiling. It simply aged. It moved from desk to desk, from box to box, from classification stamp to classification stamp. Every generation of caretakers convinced they were being responsible, careful, reasonable. We complied, they told themselves. In the present, in December 2025, that same logic is alive and well, just digitized now, faster, cleaner, more scalable. Inside DOJ, after the letters and the briefings and the carefully calibrated responses, there is one more meeting. Not large, not dramatic, just a handful of senior officials and career staff. Someone brings up the historical parallel again, the old case from the opening of this story. You know, they say, that file was technically released too. Eventually. Someone else nods. Yeah, they say. After most of the people involved were gone. That line hangs there longer than anyone expects because it reframes everything. The Epstein files, the redactions, the missing materials, the restored documents, none of that exists in a vacuum. It exists in a lineage of institutions that believe time itself is a tool. Delay long enough and urgency fades. Release enough and pressure dissipates. Comply technically and history softens. On Capitol Hill, a senior member says something similar, but with a different emphasis, during a late-night conversation with staff. This isn't about this case anymore, they say. This is about whether transparency laws actually mean what they say. That is the full circle moment, because the obscure mystery from decades ago, the one that began with a locked drawer and a memo typed in an outdated font, was also, at its core, about meaning. About whether records belong to the institution that created them or to the public that authorized that institution to exist. Back then, the answer was deferred. Now Congress is trying to force an answer. Another memo circulates. This one is short, almost blunt. Subject, next oversight phase, it outlines options, hearings, testimony, potential enforcement mechanisms. It does not mention the Epstein files by name until the second page, because by now everyone understands the name is almost beside the point. What matters is precedent. If this release stands as sufficient, if black boxes and negative space and procedural explanations are accepted as fulfillment, then this becomes the model, the template, the old trick, updated for the digital age. And if it does not, then something else happens. Inside DOJ, a career official says something quietly to a colleague as they leave for the night. Whatever happens, they say, this is going to be in someone's precedent binder someday. That is not cynicism. That is realism. Because that is how these stories actually end. Not with a bang, not with a villain marched off stage, but with a lesson encoded into memos, into institutional memory, into how the next generation is taught to respond when Congress comes knocking. Back in that earlier era, the mystery never fully resolved. The documents surfaced in fragments. The truth came out sideways through inference and absence and time, and the public was left to reconstruct meaning from what remained. Today, we are standing at the same crossroads. The technology is different, the law is clearer, the demand for transparency is louder. But the question is exactly the same. Do institutions exist to guard their files or to share them? Because once you see the pattern, once you recognize the old trick for what it is, you start to understand something else too. This story was never really about Epstein. It was about the file that survives administrations, the file that outlasts outrage, the file that waits patiently for attention to drift. And the reason that matters now is because what just hit the court docket and the congressional calendar and the public record is not the end of this story. It is the moment when we decide whether the ending will look like the beginning. Right.